Now let us start with fundamental rights. Part 3 of the Indian Constitution talks about fundamental rights. Articles 12 to 35 cater to the fundamental rights, and Part 3 of the Constitution is rightly described as Magna Carta of India. The fundamental rights are called fundamental for a couple of reasons. Let us understand. One, they are guaranteed and protected by the Constitution, which is the fundamental law of the land. Second, most essential for the all-round development, that is material, intellectual, moral and spiritual development of individuals. The fundamental rights as guaranteed by the constitutions allow all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. At present, we have 6 fundamental rights. To begin with, at the commencement of the Constitution, there were 7 fundamental rights. One fundamental right, that is right to property, was converted into a legal right by the 44th Amendment Act of 1978. Now let us understand the remaining 6 fundamental rights. The first is right to equality, which has been described from Article 14 to 18. Then there's right to freedom. In right to freedom, they have been talking about what all freedom that are available to an individual. Then there is right against exploitation, right to freedom of religion, cultural and educational rights, and finally, right to constitutional remedy. So, in understanding this, let us also try to understand the features of these fundamental rights first. Fundamental rights are guaranteed by the Constitution and carry a certain amount of features. First of all, we will talk about the availability of fundamental rights. Are they available to everybody? Not to everybody. Some rights are available to only citizens of India, whereas the other rights are available to citizens as well as to the non-citizen of India, that is foreign nationals residing in India. Some of them are also available to legal persons like corporation or companies. Secondly, we will try to understand whether these rights are absolute or there is some qualification or some limitation to these rights. These rights are not absolute in nature and state, as defined under Article 12, can impose reasonable restriction on them. But in this regard, when we say the law can be made by only the parliament to impose any form of restriction on this. Going further, let us also try to understand against whom these rights are available. Most of these rights are available against the state as defined under Article 12, with a few exceptions that these rights are also available against private individuals in certain cases. So as we go along, we will try to understand which rights are available against the arbitrary action or wrong actions of a private individual. So when we talk about the character of these rights, many of them are negative in nature, while few are positive in nature. So those which are negative in nature kind of put restriction on the state, whereas those positive in nature are conferring some privileges to the people who are enjoying those rights. Now the question comes is whether these rights are justiciable, can they be enforced through courts? Yes, the good part of the fundamental rights is they are justiciable, they are allowing persons to move to courts for the enforcement if and when they are violated. So who ensures that who is the guarantor in such a case? So let us understand the guarantor in such a case. In such a case, the guarantor is the Honorable Supreme Court. So the Honorable Supreme Court of India is the one who defends and guarantees these acts. Hence, the aggrieved person can directly go to the Honorable Supreme Court, not by a way of appeal, but as direct appearance. So in such case, it is not only Supreme Court, but High Court has also been granted the power to protect and defend the fundamental rights. Now the question is whether these are sacrosanct and they are permanent in nature. So the sacrosanct nature cannot be ensured, because then if they become sacrosanct, they become above everything and the day-to-day issues cannot be handled. So there are some powers which are available again with the parliament. So the parliament has the power to curtail or repeal them, but not only by a constitutional, only through a constitutional amendment act they can modify these, and not through an ordinary act. So not an ordinary act can they by a simple majority, they cannot do it. They need to do it under Article 368 of the Indian Constitution. Then the question comes is, what is the scope of operations? So when we talk about scope of operations, it is limited by Article 31A of the Indian Constitution. This is the one which is about laws providing acquisition of estates. Then there is 31B, which talks about the certain acts and regulations which are added in the ninth schedule of the Indian Constitution, and then 31C, which are about protection of laws which are abridging the fundamental rights but ensuring through DPSP. So these are three categories of the where scope of operation of the laws is allowed through the different ways and means. So, but then the question comes is, can these be suspended? So yes, these fundamental rights can be suspended during the time of emergency. But there are certain rights which cannot be even taken away during emergency. That is Article 20 and 21. We will try to understand in detail as we go ahead. Moreover, even the six rights guaranteed under Article 19 can be suspended only when emergency is declared for reasons of war or external aggression. Only in such scenario can the rights under Article 19 be denied, not in any other case. Then, whether these are applicable on military and paramilitary services. So for this also we have certain articles and provisions in the Constitution which allow or explain the application of fundamental rights vis-a-vis the paramilitary forces. So the application can be there, and who is competent to decide that? Parliament is competent to decide in that matter. And secondly, where there is military rule. Military rules means not ordinary law, but the military laws are applicable. In such scenario, how the fundamental rights of the citizen are modified is also a part which is there in the Constitution. So most of these are directly enforceable, while a few of them can be enforced on the basis of a law made by for giving effect to them. Such a law can be made only by parliament and not by state legislature, so that there is uniformity across the implementation of such laws. When we talk about part 3, the fundamental rights, the articles which are relevant of the Indian Constitution are from article number 12 to article number 35. So when we talk about this, first is article 12. Article 12 talks about definition of state. So this is only relevant vis-a-vis the fundamental rights, not as a general understanding. State has been defined in a very wider sense so as to include all its agencies. So it includes government and Parliament of India, that is the central government, state government and legislatures of each state, all local or other authorities within Indian territory and under government control. So all the local bodies also become part of it. So the key doctrine here is instrumentality or the agency of the state. Whoever works as an agency of the state becomes part of the state as per Article 12 of the Indian Constitution. In this case, a landmark judgment was pronounced by the Honorable Supreme Court of Ajay Hasia versus Khalid Mujib, where it expanded the definition to include bodies functioning as agencies of the state like PSUs, that is public sector undertakings. According to Supreme Court, even a private body or an agency working as an instrument of state falls within the meaning of state under Article 12. This is something very, very important. So whenever we talk that fundamental rights are against the arbitrary action of the state, it was always important to understand what state means here. And that has been very well defined under Article 12. Now let us move to Article 13, which talks about law. So what are those laws and whether a law should conform to some standards to be applicable or be legally tenable. So it says that any law which is inconsistent with the fundamental rights would not hold valid. So it says all pre-constitutional laws void if inconsistent with the fundamental rights. Parliament or state cannot make laws which violating fundamental rights. So any law which violates any of the fundamental rights is considered as void. What do we mean by void? It is legally not enforceable. It is not legally valid. Judicial review. Supreme Courts and High Courts can strike down such unconstitutional laws. So such laws which are passed by a parliament or a state legislature can be brought down, strike down by Supreme Court or the Honorable High Courts in such case and call them as unconstitutional. So it introduces the term law very well in Article 13, which also has been given a very wide connotation. It means permanent laws enacted by the state parliament or the state legislature. Temporary laws. Temporary law means something like ordinances which are passed when parliament is not in session, or any bylaws again, or any kind of a non-legislative source of law like custom or anything can be declared as void if they abridge or violate the fundamental rights. Article 13 declares that a constitutional amendment is not a law. Now, in this case, very important, constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court has held in Keshav Nanda Bharti case in 1973 that a constitutional amendment can be challenged on the ground that it violates the fundamental rights. That forms a basic structure of the constitution and can be declared void. So this understanding which was there earlier that as per Article 13 that a constitutional amendment is not a law has been struck down by Supreme Court in Keshav Nanda Bharti case. Very important case. We'll discuss it in detail as well. In this case, the Honorable Supreme Court struck down the view that constitutional amendment is not a law, and through a constitutional amendment, any violation of the fundamental rights can be permitted. So in this case, the another important doctrine, inconsistent law becomes dormant, not void. That was held doctrine of eclipse. That means that will not be enforceable. Doctrine of severability says invalid portions can be severed. So if in a law there are some portions which are found to be violative of the fundamental rights, that portion becomes dormant or non-enforceable, whereas the rest of the law still remains valid and legally enforceable. So that is the understanding we get from Article 13. Now let's move forward and understand Article 14, one of the very important provisions in the Indian Constitution. Article 14 to 18 talks about right to equality, a very important right. We also read through in our understanding of preamble that there is equality which has been mentioned in the preamble. So that idea of equality which was proposed in the French Revolution has been upheld in the Indian Constitution through the fundamental rights. And that right to equality from Article 14 to 18 tries to bring that into the whole scenario. So let's start with Article 14 and try to understand. The first point it puts across is the state shall not deny any person equality before law or equal protection of the laws within the territory. So there are two concepts here very important: equality before law and equal protection of law. The first one, equality before law, is a British origin concept, whereas equal protection of law is an American concept. It says that classification should be there, but not class legislation. So we'll try to understand this. It says that classification should be on an intelligible differential. So there is a difference between people that can be allowed. There is a rational reason behind it that can be allowed. Arbitrariness is a violation of equality. Government cannot act arbitrarily in this case. So let's understand this equality before law. It's a negative concept. It says no person is above the law and everyone is subject to the same laws of the land, regardless of their status, power, or position. So it focuses on equal subjection to the law. So every person, whether he is a high earning group or he is a well known personality, they will be treated equally by law. They will not be treated differently. If they have committed a crime, they have violated a law, they will be treated in the same manner. There is any special privilege, there is no special privilege or absence of special privilege to any individual. For example, a government official or a celebrity or a common citizen will be punished equally for committing the same crime. This is based on the British concept of rule of law. That is, law is supreme. Before law, everybody is equal. That's we call as equality before law. Then we talk about equal protection of law, which says that it's a positive concept. It means that the state must treat all individuals in similar circumstances equally and make reasonable classification to ensure justice. So here, if you are on same circumstances, you will be treated equally. But if you have different circumstances, you may be treated differently with a reasonable classification. So it's an affirmative action of positive discrimination to bring about substantive equality. So encourages equal treatment of equals. So if you are equal to other, then you will be treated similarly, but not necessarily of unequals. So if two people are differently placed, they may be treated differently. The law may treat a physically disabled person differently with his reservation benefits to ensure fairness. And this is something which is drawn from the American Constitution. So here we have a very beautiful picture which depicts the difference of equality before law and equal protection of law. Here you would see that these three kids who are watching a match, in the first picture, all have been treated in the same manner. They're standing on the same pedestal, same size of pedestal. This has led to a situation where one of the child, who is the smallest of them all in height, is unable to view the match. So this is an example of equality before law, where everybody is treated equally irrespective of how they are placed. Whereas in the second picture, we would see that all have been put at the same level. So they now can see or view in the same manner. So in this scenario, one of them has been given an extra support, the second one has been given a smaller support, and the third one didn't require a support and was not offered any support. So in such a scenario, this is called equal protection of law, where law is trying to bring equality through its positive discrimination. So this concept is very important. This picture gives a very good view of how the equality is understood. The Supreme Court has held that where equals and unequals are treated differently, Article 14 does not apply. As we said, equal protection by law. The right to equality, as we discussed, is not absolute. There are few exceptions to it, and the first exception is the President of India, as well as the Governor of the states. They have been granted immunity under Article 361 of the Indian Constitution, wherein it says that they are not answerable to any court for the exercise or performance of powers and duties of their office. No criminal proceeding during their term of office can be initiated against them. No arrest or imprisonment can be done during their term of office. No civil proceedings in respect of any act done by them in personal capacity, whether before or after entering the office, can be undertaken until 2-month notice has been served on them. So, no criminal proceeding, civil proceeding after 2 months, nothing can be done against them for the actions they have taken in their office. No arrest or imprisonment can be done for them. So these are some special powers given to the President of India and the Governor of the states. Similarly, Member of Parliament during the parliamentary session cannot be asked to report to any of the courts. Any action taken, any vote made, anything said during the parliamentary functions, they are not answerable in any court of law. Similarly, the foreign sovereigns, the ambassadors and the diplomats also enjoy immunity from criminal and civil proceedings as per diplomatic immunity rules of the international law. UN and its agencies also enjoy diplomatic immunity. These things set them apart from the rest of the citizens of India and thus is considered as an exception to the right of equality. There's another aspect called Article 31C, which provides that laws made by the state, where here state means everybody, as discussed in under Article 12, for implementing any law made for implementing of directive principles of state policy, if they are violating any fundamental rights that cannot be challenged on the grounds of right to equality. Here Supreme Court has upheld that wherever Article 31C comes in, the Article 14 goes out. So any law made for the implementation of directive principles of state policy cannot be held illegal or void because they violate Article 14. Another aspect about equality, right to equality, has another very important aspect of prohibition of discrimination. So there shall be no discrimination on the grounds of religion, race, caste, sex, or place of birth. But it allows some special provisions for women and children, for socially and economic backward classes, for the scheduled classes and the scheduled tribes. There was an amendment wherein by the 93rd Amendment to the Indian Constitution, reservation was allowed in private unaided educational institutions. Those reservations have been allowed under the special provisions. Beyond those special provisions, you cannot be discriminated on these grounds, whether it is your religion, your race, your caste, your sex, your place of birth. So on these 5 grounds, you cannot be discriminated against. Yes, there can be positive discrimination vis-a-vis the women and children for the backward classes. Now moving forward, taking this concept of equality in the public employment, the Constitution says there shall be no discrimination in employment under the state, and the state as defined in Article 12 on the grounds of religion, race, caste, sex, and one another aspect, descent has been added here, place of birth along with residence. So as in Article 15, we had 5 aspects on which discrimination was not allowed. Article 16 talks about 7 such aspects, that is religion, race, caste, sex, descent, place of birth and residence. But there are some exceptions to this, like residence requirement for specific posts has been allowed under Article 16.3. Reservation for backward classes has been allowed under Article 16.4. In this case, very important judgment is of Indra Swani case, where reservation ceiling has been set at 50%, that it cannot cross 50%, and also the creamy layer concept, that is economically well-to-do society strata is not permitted to take the benefit of the reservation. Moving forward, we come to an aspect of abolition of untouchability. Abolition of untouchability is very important concept. In this aspect, it talks about that untouchability stands abolished and punishable under law. So a law called Protection of Civil Rights Act was specially enacted to protect the society which was suffering, the section of society which was suffering from the untouchability issue. Article 17 abolishes untouchability, forbids its practice in any form. In 1976, the Untouchability Offences Act has been comprehensively amended and renamed as Protection of Civil Rights Act 1955. To enlarge the scope has been enlarged and make some penal provisions stringent. It refers to social disability. So what is untouchability? Let's understand that it is a social disability, that is, you are not allowed to access to the public wells, public places, market areas, imposed on certain classes of people by reason of their birth or their caste. Hence does not cover boycott of few individuals or exclusion from religious service. So if somebody is denied or a section is denied access to public places just because of their birth or their caste, that is treated as untouchability, and that is punishable under the act. Finally, we move to an aspect called abolition of titles. So when the Indian Constitution commencement happened in 1950, a lot of princely states existed. These princely states had some rights, or we would say some powers were given to them. They also enjoyed some titles, whether it was title in the name or title to the some economic benefits, some social benefits. So this was against the right to equality. So Article 18 abolishes titles and makes four provisions in this regard. It prohibits state from conferring any title. So state will not give away any title like except military or academic. So these titles like hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Diwan Bahadur, which were conferred by the colonial states, are banned under Article 18 as they are against the principle of equality. 2. It prohibits citizens of India from accepting any title from foreign states. So neither the state will give nor you will take it from a foreign state. Any foreign country offers you a title of Sir, that is not acceptable. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent. So a foreign person who is working in India, residing in India and holding an office of profit, that means under a state, cannot take any title even from its home country. No title allowed. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emoluments or any from any foreign state without the consent of the president. But there is an exception to all these. That exception stands as the national awards or the awards like Bharat Ratna, which is given, or Padma Vibhushan, Padma Bhushan, and Padma Shri awards. These awards are conferred. These have been upheld by the Constitution and they have constitutional validity. So those kind of titles are permitted, but the titles like Rai Bahadur, Raj Bahadur, Diwan Bahadur, which were hereditary in nature, are not recognized under the Indian Constitution. That's all on the part of the right to equality. So in right to equality, we discussed aspects from Article 14, which talks about equality before law and equal protection of law. Article 15 talks about prohibition of discrimination. Article 16 talks about prohibition of discrimination in public employment. Article 17 is against untouchability, and Article 18 talks about abolition of titles. Next we will be studying is right to freedom.